Now let's have a look at the torts question that appeared on the July 2004 California Bar Examination. This is an unusually difficult question. Here is a hypothetical that will test our organization and our analytical skills as much as any torts question can. Have a look with me at the call of the question, and you'll see we can't set this question up as clearly or as easily as often is the case with torts questions. 1. What claims, if any, may Melinda assert against Wilbur, and what damages, if any, may she recover? Discuss. Well, we don't know if she's going to be suing under tort or contract or real property theories, or maybe under a couple of those theories. But we do know that she's going to have one or more theories of liability, and we know that with regard to remedies, our special focus in this question will be on damages. And in torts, typically the differences between compensatory and punitive damages are at issue. In contracts, compensatory damages for breach, and then consequential damages. In question 2, we are asked, what claims, if any, may Jack assert against Lawyer? And what damages, if any, may he recover? Well, it's very common for lawyers to appear in civil liability questions, and almost always the theory of liability is going to be professional negligence. This doesn't look like a PR call of the question. We're not being asked about the attorney's ethical obligations. We're being asked about damages that the attorney may owe, and almost certainly this will be as a result of professional negligence. But that's only an educated guess. Still, we've got a very short fact pattern, and it's not going to take us long to find out what's really at issue. So take a look with me at the facts. In paragraph 1, we meet Jack, our plaintiff in question 2. He's got a very valuable diamond, but it's a difficult diamond to cut. And we learn that a mistake in the cutting would result in the diamond being worthless. In paragraph 2, we meet Chip. Chip isn't a party in the call of the question, but it turns out that Chip is married to Melinda. He's an expert diamond cutter, and he agrees with Jack to cut this diamond, with his payment being contingent on the diamond cutting operation being successful. Now, we meet Wilbur in the middle of this paragraph, and we find out that Melinda's primary claim against Wilbur is going to be based on negligence and then wrongful death. We've got our man Chip getting slowly hit by this car, not badly injured if he was normal, but he's a hemophiliac. He bleeds to death at the scene. This is a classic eggshell plaintiff case. This plaintiff did nothing wrong. This defendant is going to have to take this plaintiff as he finds him, and since the plaintiff was knocked down while crossing with the light in a crosswalk, there really don't appear to be any defenses available with regard to the driver, Wilbur. Then we meet Melinda at the end of this paragraph. She is introduced as his widow, so she's going to inherit his causes of action and her own. She's going to be able to maintain her own too. Next, in paragraph 3, we see Jack again. His diamond hasn't been cut, and he engages Lawyer, the defendant in question 2, to sue Wilbur in negligence for the $2 million difference between the present value of the diamond and its higher value if it were cut. And Lawyer blows the statute of limitations. So clearly the action between Jack and Lawyer is going to be based on negligence. But to be able to analyze damages properly, we're going to have to go into a case within a case analysis to judge whether or not Jack really did have a viable claim. Now, there is plenty of room for reasonable people to come to somewhat different conclusions with regard to the case within a case, and also with regard to Lawyer's ultimate liability. Perhaps my defense biases are going to show through again when I conclude that Jack really doesn't have a valid claim against the Lawyer. Still, that's merely my opinion, and it's supported by the facts and the analysis, but one might well be able to write a fairly persuasive answer that reaches the opposite conclusion. Okay, so we see the call of the question again. Please turn the page with me and let's have a look at the outline of issues that I've presented. And you'll see, here again, I'm not doing anything terribly sophisticated, but as usual, I am trying to be as well organized and thorough and to do the work as quickly as I can. So, Melinda's action against Wilbur is based on negligence. So we discuss duty, breach, causation, damages, and defenses. In the end, we're going to reach a conclusion in which I find Wilbur liable for compensatory damages only, not punitive damages, because there is no intent and there's also no recklessness. Next, Melinda is going to be able to maintain her own action for wrongful death. This is a much simpler analysis. I stick all of it into one section. My conclusion is that Melinda is going to win compensatory damages. When we get to the corresponding section as we review the answer, I'm going to focus your attention even more on damages. That's really what this question is about as far as the remedies aspect goes. You can never know too much about remedies, and you can never practice too much analyzing remedies issues. Next, we consider Jack versus Lawyer. I discuss it just as we anticipated, under negligence. I break it up into elements, and I consider the case within a case in damages. Now, you may well have considered discussing the case within a case up front, or within duty and breach, and that would have been entirely reasonable also. What counts is spotting the issue and finding some logical home for it, not putting it in a specific place within the analysis. Okay, well that's enough to consider the outline of issues and the fact pattern, so please now turn your attention to the model answer that I've written, and you're going to see again, once again, I'm especially working hard to find a home for the facts and to analyze these facts as comprehensively as I can and with as much respect for the law as I can. So notice up front, as usual, I lead with the facts. I explain that Melinda was married to Chip, who was killed by Wilbur. I explain up front that she's going to be able to pursue negligence and wrongful death claims against Wilbur, and up front I indicate that she has no battery theory because there was no intent on the part of Wilbur to cause the harmful and offensive and ultimately fatal touching. So up front with regard to negligence, very briefly, I define it. Then I spend all of my real efforts in the analysis. The duty and breach sections really are very straightforward, and although I find a home for some of the details, this is not where the real action is. Wilbur was a driver. He had a duty as such to operate his vehicle with ordinary care, and he went through a red light and hit somebody. Almost certainly that's going to be good enough to qualify for negligence per se, since every jurisdiction has traffic laws that prohibit or make a violation out of driving through a red light that you ought to stop for. So next, I turn to causation. And here I discuss the hemophilia aspect of the case, and I indicate that the eggshell plaintiff doctrine is going to result in Wilbur being unable to escape liability. With regard to damages, it is clear that there are very serious damages. Now, will Melinda be able to recover the expected money gained as a result of her late husband successfully cutting this diamond? Well, I say almost certainly not. I consider this to be a discussion a little bit more within wrongful death, but ultimately I conclude that both of her claims against Wilbur are going to be successful, and that she is going to get compensatory damages for loss of consortium, lost income, and any other foreseeable damages. She doesn't get punitive damages because there's no intent and because there's no recklessness. Now, suppose you wanted to examine these facts and give her a chance to obtain punitive damages. The way to do it would be to characterize the defendant's driving as reckless. And if you have a plaintiff bias, that might be how you saw this question. You might have looked at this and said, well, wait a second. Here's a driver going through a red light, slowly running somebody over. He can't be paying attention at all. This has to be above ordinary negligence. Okay, fair enough. That would be a reasonable result as well. All I can say is, I just hope you never turn up on one of my juries. So now, let's turn to Jack versus Lawyer. This is a fairly straightforward set of facts, but again, there's plenty of room for reasonable people to reach somewhat different conclusions. Here we've got the facts that set up the problem are Jack hired a lawyer to pursue a negligence claim against Wilbur, and the lawyer failed to meet the statute of limitations. Now, most of us look at these facts and we immediately conclude that this lawyer is on the hook, civilly. and that his failure to file is one of the most fundamental breaches of duty of competence or the duty of care that a lawyer can make. So take a look at duty and breach, and I think you'll find that I correctly point out that this failure to file before the statute told would be a breach of his duty in every jurisdiction. But in order to determine full liability, we've got to consider the case within a case. I do it under damages, but you might well have chosen to do it earlier, or maybe even upfront, before going into the analysis in depth. Now, I look at the case within a case, and my points are, essentially, number one, there's no guarantee that there would have been a successful cutting of this diamond in the first place, and that, thus, this is a fairly speculative case. So I also point out that there could be a theory of liability based on intentional interference with contract, or maybe negligent interference with contract, but that's a very weak claim because the defendant Wilbur hadn't any idea about the contract, and thus it really seems a stretch to find those theories viable. So when it's all said and done, I examine the case within a case, and I conclude that this plaintiff, Jack, doesn't really have a valid theory of liability against Wilbur in the first place. So in the end, I conclude that the lawyer is off the hook and is not going to be liable at all because he shouldn't be punished for his failure to file a frivolous lawsuit. Well, here again, maybe you're able to see a defense bias on my part coming through. Maybe you looked at the case and said, sure, the damages might be speculative, but we're going to give this plaintiff his day in court, and to the extent that he can prove up damages, he's going to be able to recover them. Now, I don't think any of us disagree with the fact that this lawyer's failure to file the lawsuit in a timely manner would be deemed negligent, assuming that the underlying case has any potential value. I hold that it almost certainly doesn't. Therefore, I absolve the lawyer of civil liability. You could well interpret the facts along the same legal framework and reach the opposite conclusion.